call Jacinda Ardern.
Thank you, Mr. Speaker. I'm pleased to rise in support of the Children, Young Persons and Their Families Advocacy, Workforce and Age Settings Amendment Bill. And as a party, Labor has generally given cautious support to the process the Minister undertook when she introduced the expert advisory panel who carried out both an interim and final report setting out the reforms that they believe were needed for our child protection and child welfare system in New Zealand. And we came into that process with an open mind because we ourselves had pushed for so long that changes were needed in order to improve the outcomes for children. It was our view, however, that it was never fair to blame social workers for the situation that we had in New Zealand, given that we have not been properly resourcing and supporting those social workers for some time now. In fact, in Select Committee today, Mr. Speaker, that was confirmed when we questioned the Minister over funding for child, youth and family, and she admitted that over the past few years, $52 million has been taken out of child, youth and family in what's been called efficiency savings. But what do those efficiency savings actually represent? It included the holding of vacancies. When social workers left jobs, they simply weren't replaced. The way that holiday pay was paid out and whether or not programs were indeed delivered. $52 million taken out of a department that couldn't afford it. And what's proof that they couldn't afford it? The Minister this budget put $36 million back in 1 year alone because she's acknowledged that that was needed just to tread water. So I make those comments because whilst this bill is welcomed and we're pleased about it, we do need to acknowledge that in the here and now, we do have a department that it continues to be under considerable strain. And how can we truly say they have failed when we never resource them to do the job properly in the first place? Mr. Chair, Mr. Speaker, on the specific provisions in this bill, though, there's one element in particular I'm really pleased to stand up in support of, and that is the raising of the age of care and protection. When we lost last election, Mr. Speaker, to stay sane as an opposition member for another 3 years, having already, I will defend my sanity, having already served 6, I wrote a bucket list, an opposition bucket list, things that despite not being in power, I wanted to see happen in my term in opposition. And at the top of the list was an increase in the age of care and protection. It never ever seemed fair to me when I first came into Parliament that once a young person who's under the care of Chief Executive in foster care, in residence, in kinship care, that once they turned 17, once they had their 17th birthday, no one had responsibility for them, not one person. Now, a parent would never do that to their child. A parent would never say on the 17th birthday of their child, pack your bags, leave the house, I have no responsibility for you any longer. No financial responsibility, no emotional responsibility, nothing. And yet that's what we do to our young people who you could argue need more support than anyone else. And so we as a Labor government, when we were in government, we're set to change this. We had a bill on the order paper, an amendment to the Child, Youth and Families Act to change the age of care and protection. But we lost. So when I came in, I remember when I was the Youth Affairs spokesperson, every time a bill came up where I could make an amendment that might lift the age, I did, every time. Not only that, we ran a petition and tried to get public sympathy for this issue as well. Action stations came on board and the petition grew. It seemed to have got some momentum, but none of it would have happened, and I want to acknowledge the work of Dingwall Trust, who works with these young people every single day. And they were one of the first organisations that put a young person in front of me and had them tell me their story. Lifewise, another organisation working with the homeless who see the other side, the repercussions of this policy. Those are just some of the organisations who did awesome work, championed this issue, and I believe got it here today. So I'm pleased we're ticking off. We're ticking off an item that just so happens to be on my opposition bucket list. But it would be remiss of me not to add, Mr. Chair, though, that on the flip, Mr. Speaker, that on the flip side of that, unfortunately, we are now going to have a separate age for care and protection than we will youth justice. And that is a lost opportunity. There is a reason that our care and protection age and our youth justice age are linked. And it is because if you have a young person committing crime, then you will often find there are care and protection issues. In fact, this was confirmed by Judge Andrew Beecroft, who in a speech not too long ago said that of the 1,982 offenders in the youth court last year, SIFs had prior involvement in 67% of cases. In 67% of cases. There is a reason that our Child, Youth and Families Act includes the youth justice provisions in it. So why are we only raising one element? It makes sense to have young people as long as possible in the youth court, not only because of our United Nations Convention on the Rights of the Child responsibilities, which we get whacked with every time because we haven't raised the age, not only because of that, but because the youth court is a highly successful, interventionist, confrontational, personalised process. I've heard much come from the community of late that the youth court does not hold young people to account. Two challenges to that. I have never seen a process more confrontational than what I've seen, for instance, by the youth and rangatahi courts. The young person is at the centre of the process. They cannot sit back and not take responsibility in the way that you see our adult system work, where they can almost be a bystander to the process. They're at the middle. The youth court has tools that enable them to cater the sentence to that young person, and it could include a long stint in a residential facility, but it also can include wraparound services for the family that young person has come from and will go back to. It understands that their environment has played a role. And the other important point is that if the case is severe enough, the youth court can send it on to the adult court. The provision is there. The youth court is a gem in our justice system. We should be sending more young people to it. And I really implore the government in the work that they're doing to assess whether or not that age should go up, I really implore them to consider that positively. I want to come to the two other provisions in this bill. Around advocacy, the ability of a young person to personally have their views heard, but also the establishment of an advocacy service for young people in care. Absolutely. In Australia, they have something similar, particularly for children in foster care. We have needed that for some time. One point I want to, a point of caution though, Mr. Chair, we must resource that properly. Currently, the Children's Commissioner has that responsibility to be a voice for young people, but he's already said that that's one of the things that he's had to step back from because he has not been properly resourced and his funding has remained static for the last 8 years. Whatever we do, we have to make sure we support it properly. The involvement of the philanthropic sector in designing this, my only question will be, is that a sustainable way to create what is going to be a piece of core service in legislation? We design something with the philanthropic sector, are we then reliant on them to make sure it continues to be delivered? No young person should rely on their advocacy being funded out of goodwill. It needs to be more sure than that. And whilst I welcome the fact that people have an interest in this area and want to contribute, we must give it a stable footing. The last point, Mr. Chair, and this is where our most significant reservations sit, and that is around enabling a wider role of professionals to have core responsibilities in discharging functions under the SIFS Act. There is a reason that we train our social workers comprehensively. There is a reason we are advocating that social workers must be registered. This is a professionalised sector that perform a very critical role. They make the decision to remove children from their family. It doesn't get much more serious than that outside of incarcerating someone. It's a specific role that requires expertise. Now, the delegation that we're talking here, we don't really have specificity around what's going to be delegated to other professionals, but the idea that the Chief Executive, not this Parliament, but the Chief Executive can make that decision simply by putting a notice on a website does not sound like a robust check and balance to me, does not sound robust enough. We will be questioning that at Select Committee. Thank you, Mr. Chair.
Mr. Speaker.